Bougie gang, good morning. Good morning, good morning, good morning, good morning, good morning. How's everybody doing? This is not a figment of your imagination. We are live. It is early. It's is it Wednesday? It's Wednesday. Why do I even bother to say the days of the week? Because I mean, does it even matter? We just know it's a day. It happens to be Wednesday, and it's still early. It's not even 8:30 yet, but we're getting there. Anyway, guys, good morning, good morning, good morning. I just wanted to bring you this little tidbit before the day gets away from us all, and we have a chance to talk about it at lunchtime. Okay. Okay, because I feel like time is going to be real precious today. There's a lot going on. Good morning. Good morning. Today's the day he's going to kick. Today is the day he's going to kick in my Miss Carlin's. We're going to see. We're going to see. I wonder, I don't even know. We don't even know I guess we can talk about that for a minute. I didn't intend to stay too long this morning, but let's talk about it. Good morning, everybody. Good morning, Bougie Gang. Good morning. Good morning, Bougie Gang. How are you? How's everybody doing? I hope you had a wonderful evening. It's Wednesday. It's morning. Today is October 2nd. And Ernest Williams does have court today. Ernest Williams did have court a week ago, actually. Has it been a week? It's been a week since his last court hearing. And Sir got his final judgment and decreed. It was decreed and declared. Okay. It's a decree and a declare. And I said, let's do a little bit of reading time this morning. Attorney Edwards needed to complete and send it over to the judge, which she did. Miss Regina Edwards, attorney for the petitioner, Miss Shirley Strawberry. Okay. Anywho, she did that. She said she was going to send it over no later than 5 o'clock that day. I don't know if that happened or not. This got filed on September 30th, which includes obviously the seal of the Superior Court and the judge's signature. So quite possibly that's a document she needed to complete, sends it to the judge. He does his part, and then it's a done data, right? Anyway, this is the close. I'm sure I haven't looked at the docket for this, but I thought about this morning. This case, I'm sure, says closed now. It's case closed. Next case. Okay. And next case will be today, because today is another case for Mr. Williams. Okay. Let's get into it. Okay. Final judgment. And decree of divorce. It's been declared and it's so decreed. Okay. Let me see if this size works for me. I wonder if I move this over here, is that gonna mess up the view? It does. Hold up. Let me move this back. Girl, even with my glasses, it's like, baby, that actually might be a little more like a little bit better. Okay. Final judgment and decree of divorce. This matter came before the court. Let me just say welcome to everybody real quick. We had some technical difficulty the first time. Hopefully you guys are hearing me well. I went ahead and restarted my computer because I was like, God only knows. God only knows. Sis has so many tabs open, and I mean, it's a lot. It's giving a lot. And when my computer starts to do stuff like that, I just go with, it's time to restart. Just go ahead and restart it. Okay, guys. Final judgment and decree of divorce. This matter came before the court for final hearing on September 25th, 2024. Petitioner Shirley Strawberry was present and represented by counsel. The respondent, Ernest L. Williams Jr., appeared pro se, which means no lawyer, via Zoom from Cobb County Jail. Comment down below. Was she being messy by mentioning that or just stating the facts? He was pro se via Zoom, but everybody was via Zoom, weren't they? Okay. From Cobb County Jail. Was Attorney Edwards stating facts or being messy or both? Okay. After reviewing the file and considering the same, the court finds as follows. You guys are saying both. She was being both. Okay. All right. The parties were married. The parties were married January 19th, 2015. Okay. So when that judicial assistant made a mistake, remember the parties were married on January 9th, 2015. Petitioner filed her complaint for divorce and other relief on April 17th, 2024. I am waiting for a document that will validate that, the January 9th, 2015. Not that that's still in question because we have a document signed by a judge stating that that was the fact, but just for our own review, the we will have that soon. Respondent has been okay. So the parties were married January 9th, 2015 in Atlanta, Georgia. Petitioner filed her complaint for divorce and other relief on April 17th, 2024. Respondent has been incarcerated since approximately 2021. I'm going to have to say, Attorney Edwards, you made a mistake on that, boo. He got arrested in 2022. It wasn't approximately 2021, but I guess if that's your approximate, I don't know, but that's not a correct date. Respondent was served by Cobb County Sheriff's Office June 4th, 2024. Respondent failed to file an answer or otherwise respond to petitioner's complaint. That all sounds accurate to me as a bystander, okay? Point 2, the parties separated on or about March 2022 and have lived in a bona fide state of separation since that time. That's what the complaint said, okay? There are no minor children born to the parties during the parties' marriage. I believe that is correct. And the petitioner is not now pregnant. Okay, that's what they say. Okay, because that would add an additional complexity to the divorce, right? Petitioner has sole and exclusive use and possession of parties' marital residence located at, and I redacted that part, okay? That part. In her complaint, petitioner states the parties have no joint marital assets or debts acquired during their marriage, which are subject to equitable division. This is what I'm going to say on number 5. Nesto had to have been. I know there's people out here that think that Nesto had his own money and good. I think Nesto was broke and using all of Shirley's money, but that's just my opinion. I think Shirley was very generous to wipe the slate clean because there has got to be debt that has been acquired. Just the F450, the F350. I think Dion's paying for the F350, but it's in her name. So I think she was very generous. I think this is one of those, I don't fuck with you and I don't want to, and I don't care about that bit of money, and I'm just going to suck it up. That's just my opinion because I cannot believe he didn't run over a bank account. I cannot believe that he doesn't have some overdraft fees or a small, even if it's a bad credit card, that he didn't have something somewhere when he got plucked off the streets, unknowing that he was getting ready to be plucked off the streets and not to return anytime soon. Okay. He had to have had something going on. And maybe it's all been written off by now. I don't know. But at the end of the day, I do think that she probably assumed and acquired or paid off some things and is being very generous by just stating that there's no, because I mean, why bother to make it more complicated? He doesn't have any money right now, right? Anyway, that's just my opinion on number five. Six, respondent did not file an answer or otherwise respond to petitioner's complaint. The court set the final hearing for September 25th, upon which date respondent appeared and stated he did not object to the divorce. And that is all true. He was there, he was in court. We did see Nesto if you were on the Zoom. And he did state that he did not object to the divorce and basically agreed that to Shirley's assertion that the marriage was irretrievably broken, and that he agreed to the divorce. Okay. All right. The court hereby orders as follows. Upon consideration of this case, upon evidence submitted as provided by law, it is the judgment of the court that a total divorce be granted, that is to say, a divorce in vinculo matrimony between the parties to the above stated case upon legal principles. And it is considered, ordered, and decreed by the court that the marriage contract heretofore entered into between the parties to this case from and after this date be and is set aside and dissolved as truly and effectually as if no such contract had ever been made or entered into. Petitioner and respondent in the future shall be held and considered separate and distinct persons altogether unconnected by any nuptial union or civil contract whatsoever, and both shall have the right to remarry. That's just a very important statement. Alimony, we already know this. I mean, come on now. Nesto doesn't have a nickel, and Shirley doesn't owe him a nickel. Shirley doesn't owe him a thing. And I'm going to just go on a limb to say he probably really owes her. He owes her more than anything, um, because he wore her out. Okay. Real and personal property. The parties do not jointly own any real property. Each party shall be responsible for any and all expenses associated with his or her residence, including but not limited to mortgage payments, taxes, insurance, utilities, and alike. Petitioner shall be entitled to exclusive ownership of any personal property titled in her name or in her possession. Respondent shall be entitled to exclusive ownership of any personal property titled in his name or his possession. Each party shall be responsible for payment of his or her own debt. Each party shall hold harmless and indemnify the other party for any collection efforts related to debts assumed under this decree. Each party shall retain his or her own bank accounts, retirement accounts, vehicles, and any and all personal property in his or her own possession. So that's interesting. Retirement accounts, her 401k, um, everything. So he didn't ask for anything. She didn't offer anything. He's not entitled at this point. It's done. That he didn't ask for anything. He didn't say anything. It's, yeah, he can't come back later. Um each party shall be solely responsible for paying his or her own medical coverage, medical bills, including deductibles, non-covered services of any type, and shall pay his or her own premiums. Vehicles, petitioner is awarded sole exclusive use and possession of vehicles currently in her possession. Petitioner shall be responsible for any and all costs associated with said vehicle, including but not limited to any indebtedness, insurance, maintenance, tax, and the like. Respondent is awarded sole and exclusive use and possession of the vehicle currently in his possession, if any. Respondent shall be responsible for any and all costs associated with said vehicle, including but not limited to any indebtedness, insurance, maintenance, tax, and alike. All parties shall continue to file separate income tax returns for the year of 2024 and each subsequent year thereafter. Decree and ordered, entered this 30th day of September 2024. This was the reading of the final judgment and decree of divorce for Shirley. It's been a long road, finally free and single, eligible to date, bachelorette, and her no good up on some felonious RICO ass charges, due in court today with an outfit supplied by his side chick, Mr. Ernest L. Williams Jr. Okay? It's a wrap. It's a wrap on this marriage. It is a wrap. It's done. She is free. Can we get some Shirleys in the chat? Okay? That's it. That's all, guys.